This one. I think
But I appear on behalf of the petitioner. Probably today being the first day, my lord, Lordship will take it after 2, 3 days later. I don't want to do it expeditiously.
what is this? One of
Final
those.
order of the learned tribunal.
You are for the petitioner.
I am for the petitioner.
It's come up for the first time.
First time.
Let's see. If they are required, then we can.
We have served, but the affidavit of service
You have served.
is not yet ready.
What is the issue? Just give
But,
a brief background.
here, my lord, what happened is that the selection process,
Yes.
he was given 1.2 marks less than the private respondent on the basis of uncommunicated ACRs. Had the ACRs been communicated, then it would have been something else. Uncommunicated ACRs, your lordship knows the law very well, cannot be taken into consideration, and therefore I should have been given the benefit of that. Then 2 rounds of litigation, Lord, and we had taken the point that the uncommunicated ACRs, subsequently by orders of the learned tribunal, we were asked to make representation. We made representation. Representation was not properly considered. That was our point before the learned tribunal. And we had this point also.
So if it was not communicated, how you made the representation?
Then later, by virtue of the
After.
order of the learned tribunal, it was communicated. We made representation. Representation rejected, a second round of litigation, and all these continued. But if your lordship come to page 4, your lordship will see the gist of the case. Page 4.
Of the impugned order.
No, of the petition, my lord. To shorten the entire issue, my lord, I've just. The gist of the case is in these 2 pages, my lord.
So if the ACR is excluded, according to you, what will be the points you will get as for the service record?
Service record, my lord, because the grading was good. These 2 years, my lord, grading was good. They would have been automatically 2 marks, 4 marks. I would have been more than the private respondent. That was the entire case. since ACRs were communicated on the basis of the order, we are bound by our earlier order. We will not look into anything else.
So the earlier order, where is the earlier order?
The earlier order is there, my lord. Page 162.
Five years.
5 years. Actually, my lord, the short point is whether uncommunicated ACRs would have been considered while taking the decision. Even if subsequently, my lord, I have made representations, etc. But ultimately, fact remains that those representations, etc., cannot relate back to the period. That aspect I have taken. This is a new point, my lord. I believe your lordship would require some consideration, my lord. But I'll get to know who is there, the learned advocate, my lord. I'll come back on after the 5th, my lord. By that time, I'll get to know who is there. Because this is a serious issue, my lord. Just because I have to make representation doesn't mean it takes away my right to be considered that once the ACRs, not uncommunicated ACRs, whether they can at all take a decision on that. And that is decided by the Supreme Court, my lord, in several judgments. Tribunal only goes to this, my lord, that since representation was made, representation has been considered, therefore nothing remains. But that is simplifying the matter.
Where is the past pursuant to this?
My lord,
Where is the speaking order? Past
speaking order. My lord, at page 171. Achha. only 2010-11 are the years where good was given. Others are very good. So
And where is the rule under which this APRs are the grading is granted?
uh,
Your whole point is that an adverse ACR cannot be relied upon without communication. So where is the rule which says in what circumstance an APR is adverse?
Milord, that rule, Milord, of 2011 they have cited. That has no manner of 2001 because of the subsequent judgments of the Honorable Supreme Court. That is useless.
No, which 2001 rule?
Milord, page 172.
Yes.
Lordship kindly comes to the last but one paragraph. You have alleged. Lordship has got it, Milord.
Yes.
Non-communication of adverse remarks.
Yes.
It may be appreciated that there were no adverse remarks available in the APRs. So question of non-communication does not arise. Milord,
Yes.
good. Moreover, grading of good is not an adverse remark. Milord, this is of 2001, which has been given the go by subsequently by Supreme Court. It has said that whatever, if someone is adversely affected in any manner, you have to communicate. So this 2001 rule, which they are citing, that is non-est in the eye of law.
No, therefore we are saying that rule contemplates a particular points to be awarded for someone who has been evaluated as good. It must contemplate a certain provision regarding what is the points to be evaluated to someone who is assessed as very good. Is there a difference between good and very good?
There will be a difference.
So where is that? Let us see. Unless there is a difference, whether it is good or very good, how does it matter?
No, because the
Adverse would mean poor or something like that. So this is not adverse. This is good. This is not an adverse comment. Good may be lesser than very good. Good may be lesser than excellent, but nonetheless, good is a good. It is not a negative entry in the ACR. So what is the difference between good and very good?
about two marks, I think, but I'll come back with that.
That we'll have to see, because unless it acts to your prejudice, because somebody has given very good and it has been downgraded to good.
No. Here, my lord, good is given for the 2 years, 2010-11, 2011-12, and the rest is very good.
Yes, only 2 years you have good. The later 3 years you have very good. Yes.
Now, because of that good, I got lesser marks.
That is what we are trying to see. How is good and very good? Is there a distinction? Is there any parameter set out that for good this points has to be awarded and for very good this point has to be awarded?
I'll come back.
Because unless they are based on a particular yardstick as regards grant of marks, whether this point arises at all is an issue we are trying to understand.
I appreciate it. I'll come back. I'll give a notice and come back after 5th, Lord. Lordship keeps it. But point is, Lord, I'll be taking a wider thinking. Your Lordship will kindly consider that whether it is good or very good, etc. Ultimately, ACRs have to be communicated. That is Supreme Court. And that is subsequent to 2001. This notification of 2001 naturally loses its strength because of the judgments of the Supreme Court, that whatever be the position, you have to send me the ACR.
That is all right, but the
now
time and the point of communication, whether that delay or lapse has actually resulted in prejudice,
Yes, Lord. Here prejudice is.
that is exactly what we
I
are trying
have
to see.
appreciated. I have appreciated. I'll come
Unless
back
there
with
is
this,
a
sir.
scope for contending that this lapse or delay which you allege, even if it is correct, has resulted in some prejudice,
Here, my lord, the
it
prejudice
will
is
become a.
I have got 1.2 marks less than the private respondent because of.
We don't know. We don't know. That's why we are saying
No,
whether you would no whether you would have got 1.2 marks additional if it was very good.
Definitely.
So where do we get this?
I'll come back. I appreciate what is.
Where do we get this?
Because your lordship wants to go to the root of the thing, that what is the.
That rule must be contemplating if there is a different kind of grades which are to be awarded in the ACR, which may be starting from poor or very poor, unsatisfactory, poor,
Yes.
some, and then going up to good, very good, or
Yes.
maybe another excellent. We don't
Excellent. Yes.
But
I'll come back with that.
know.
After the fifth, lordship will take up. I'm great.
That's it. কত দিচ্ছ?
আইটেম নাম্বার 3 এই ডিসপ্লে হচ্ছে না দেখ
None appears on behalf of. Instead of 2, 3 weeks.
Item number
Sunday. साफ करना to clean this. They're clearing.
weeks. Item number 5.
Item number 5, my lord, I appear for the petitioner, my lord. Am I audible, my lord?
Online. Yes.
I appear for the petitioner, my lord.
Yes.
case of the petitioner is this, my lord, the petitioner was a doctor. He tendered resignation. And my lord, I approached the learned tribunal. Learned tribunal passed an order directing to consider my case. Now, my lord, they have rejected my case on the pretext of dearth of doctors, which has been, my lord, by your lordship's order has already negated the issue. Issue is no more less integra, but still they have done so. Now, my lord, the rejection order your lordship will get at page 66. Page 66 is the rejection order.
email পাইতে দিয়ে দাও। হ্যাঁ
So,
So, my lord, being aggrieved by the rejection order, I moved the learned tribunal, my lord, as because your lordship knows the tribunal is not functioning. And my lord,
you are saying serve.
yes, my lord, it has been served, my lord. It has been served. If it was served before vacation, it has been served, my lord.
Service has to be effected on the government pleader or on the respondent.
My lord, on the government leader. As because all the respondents are my lord, government employees, my lord, or the government departments, it has served upon the government leader.
Yeah. This receipt is issued by the GP office. This one.
Yes, that is the receipt.
Give him a copy. None appears on behalf of the respondent. List on Monday week.
My lord, let it retain its position at my lord.
Yes, at the same position.
Deep lawless, my lord.
Affidavit of service file be taken on record. Obliged.
We have taken note of the contents of the affidavit of service.
That's
Deep lawless.
keep your.
Item number 6.
I'm appearing on behalf of the Public Service Commission.
Affidavit of reply, my lord. And then, my lord, it is already served. Yes, my lord. And my lord, here the 4 question is under challenge here. Already West Bengal Public Service Commission, they agreed they made a mistake. They give already 2 marks by their affidavit in opposition. They agreed on that. So my marks is yes, in this proceeding. After filing the writ petition, because when I filed this writ petition at that point of time, my marks was 274 in aggregate. And the last selected candidate marks was 276. They agreed in their affidavit in opposition, I am entitled another 2 marks. So my marks is equated with the last selected candidate. If I got even half of marks, then I come in the zone of the consideration. Malad, kindly take their affidavit in opposition first, Malad. Thereafter, Malad, I peruse thereafter my affidavit and reply as well as the others answer script. On the last occasion when matter.
Yes, Lordship.
Yes.
Lordship, it is the question where the petitioner has also given a wrong answer, Lordship. 270, there was a tie between last recommended candidates and the petitioner. But as per the full commission's decision, when there is a tie, there is a rule that the person who has got higher marks in personality test, that candidate will be succeeded.
He will prevail over the other.
Yes,
He or
the
she will prevail.
last recommended candidates has got more marks than the petitioner. Therefore, even if we give 2 more marks to the petitioner, there would be a tie, And as per the FC Commission's decision, the last recommended candidate,
You have said even if we would give, or you have given two additional.
we have given, there is a tie, but the last recommended
But what
candidate,
he is saying that two other questions you have not
Not
considered.
two, my lord, four. Total, my lord, 16 marks.
All right, so four other
Lordship, on
questions.
the last occasion, they have submitted the question in a mathematics who has to do more percentage of work. He has, the candidate petitioner has given a wrong answer. And the comparison the petitioner is showing before the court in respect of two other candidates, Lordship, the three question papers of three different candidates have been evaluated by the three different examiners. Two have chosen to give half marks for attempting the questions, but it is the discretion of the
Yes.
it is the discretion of the examiner whether he will give marks or not, because all of them have given wrong answer.
So according to you, apart from these 2 marks which you have found him entitled to, he is not entitled to any further marks
No.
for the answers that he has given.
Yes.
Because they are wrong answers.
Yes, wrong answers.
So this is in respect of all the 4 questions that he is alleging.
Yes, Lordship. 2 marks we have given.
That is over.
Yes.
We are not on that.
Yes.
Whatever you have accepted, he cannot.
Yes.
He will not say anything that why you have accepted. And we are also not interested if you have accepted.
No other marks he is entitled to.
He says apart from that, there are 4 questions
Yes.
for which he has wrongly been deprived of marks. Which are those 4 questions?
May I place my case, my lord?
Yes. No, is this the dispute?
Yes.
So let us see where are
Yeah,
the
one after another, and even they give the marks to others for giving the same answer which I gave. I just show one example of that.
No,
But-
where are these 4 questions?
Yes,
First,
the 4 question is question number 3K,
question number?
9, question number 13, and question number 4A.
Where are these?
Yes, my lord. I peruse one after another. Question number 3K, page number 98. Kindly turn, my lord, page number 98.
98.
100. My lord, page number 98 is my kindly turn, page number 100. That's my answer.
No, 98 is answers.
Yes, my lord.
We are asking you where are the questions?
Lordship, questions are at page 66.
66. Yes. Right. Thank you.
So
Yes.
let us first mark the questions which you say are
Yes.
you have wrongly been evaluated for this. Which are
100, page number 100. Kindly turn page number 100. 3K, in the bottom portion.
why are you showing us the answers? Repeatedly we are asking you where are the
Page
questions?
number 98. I told it, my lord. Page number 98 is the question. What is, my lord? Give the antonyms of Herosus. 3K.
Yes. So
My answer is,
this is one question. Where
one
are the
question.
other 3 questions?
other 3 question is question number 9, page number 66.
Yes. Then
And question number 13, page number 67. Question number 48 is page number 40. Because in various papers, the
13
question,
at page 67.
yes, my lord. Question number 13 is page number 67.
Then
And question number 48 is page number 40.
40.
40. I start from question number 3K. That is first.
43K.
Yes, my lord. That is, I start from page number 98.
Longest national highway.
Page number 40. Write 2 units of energy. Page number 4H. 4H. Question number 4H. That is under challenge. So page number 40, question number 4H is under challenge. Page number 67, question 13 is under challenge. Page number 66, question 9 is under challenge. And
66 or 67?
67 is question number 13. And 66 is question number 9. And question number 3K is in page number 98. That is the question by the West Bengal Public Service Commission.
There are 4 or 5.
Four question. Question number, I just repeated in the cost of repetition, my lord. Question number 48, page number 40. Question number 13, page number 67. Question number 9, page number 66. Question number 3K, page number 98. I start from page number 98, my lord. Question number 3K. That is the question. Give the antonyms of pheresis. Question, page number 100 is my answer. Kindly turn, my lord. Page number, it will kind enough. My lord. Antonym of pheresis is calm. That's my answer, my lord. And they crossed it, give 0 marks. Now, my lord, kindly take affidavit in reply, which is filed today by me, my lord. The annexure part. One of the order sheet passed by the West Bengal Administrative Tribunal. Today, I just filed it, my lord. I believe my lord got it. Kindly turn page number 7. The second paragraph, the last 3 lines. Got it, my lord? For instance, only half marks was given to her for question 3K, which has asked the antonyms of pheresis. The applicant answer is calm as the antonyms. So, other candidate
This is passed in your OA.
No, other matter. In OA number 30 of 2024, Mombita Shaha versus State of West Bengal. In that matter, Mombita Shaha got half marks for giving this answer. She is not satisfied with that half marks. She challenged it, and from that order sheet, it is evident that West Bengal Public Service Commission give her half marks for giving that answer. But in my case, for giving the same answer, not given half marks also, 0. So even I got the half marks, then I come in the zone of the consideration. So equal opportunity in public employment, that's my fundamental right.
This is not the stand, it doesn't appear to be the stand of the commission. The applicant believes.
No, madam. That is from their annex, that is, Malad, kindly may I read it, Malad? Because of that already given half marks. Yes. The applicant has filed this application praying for direction to the Public Service Commission West Bengal to reassess some of the answers given to the applicant to the question. The applicant had participated in the recruitment process of the post of the supervisor female ICDS. When the final merit list was published, the applicant name not being featured. She filed an RTI before the commission for photocopies of the one that is 3 arithmetic 4. Her RTI request was allowed and the photocopies of the answer sheet written by the applicant during the exam was given to her. While giving through her own answer, she detected some answers she had given to the question where treated wrong or partly right, not given full marks. The applicant believes that the answers she had given were correct and the commission was wrong as not correct or partly correct, thus not giving her the full marks she deserved. For instance, she giving the instance. For instance, only half marks were given for question 3K, which had asked the antonyms of the predecessor. That means half marks was given. The applicant answer come as the antonym. So applicant, his humble submission was that he was given half marks.
Correct.
Instead
That
of
is what we said. That is
Yes.
her submission.
Yes, no, but she was given half marks.
That is her
She is
submission.
entitled for full marks. That is his submission.
That
But
is-
he was given half marks for giving calm as an
As the tribunal has said that yes, she was given half marks.
half marks. Yes.
No, that is only her submission.
No.
She can submit anything.
Minor, kindly see, I read it again. For instance, only half marks were given to her.
No, you can't read for instance. You have to read the applicant believes.
For my case, half marks also not given. That's my
We
case.
don't know whether she was granted. This
Yes, that is.
All right. So you are now repeating the same thing twice and thrice.
My lord, because of
The
that,
point
the
is-
case of repetition, my lord, I
No, there, please don't repeat. Please try to understand what we want to know from you. Then you may say, we say you read this from this point. The applicant believes that the answers she had given were correct and the commission was wrong in treating this as not correct or partly correct and thus not giving her full marks she deserved. For instance, only half marks were given to her for question 3K, which had asked the antonym of ferocious. The applicant answered calm as antonym. This is all her submission. This is not a finding of the court. This is not the stand of the commission. So she has said that she believes that she has been granted insufficient marks, even though she has answered this correctly, she has been granted half marks. She has said so. That is only her submission. This cannot be taken as a finding that yes, she has been granted half marks for 3K. This cannot be. Yes. I have got half. Yes. Yes.
But there is two parties. One is the applicant and another one is the applicant being cooperative PSC.
Hmm?
PSC is the applicant article 12 authority. He treated all the candidates similar manner. The PSC gave half mark to a candidate for giving an answer as exam.
We don't know. That is what we are unable to find from the order of the tribunal. You are saying that this is a finding. We say no, this is her submission. That is the only difference between you and us today. All right. Which other question? Which other question? Come to the next. Yes.
Question number 4H, page number 4.
4H, page 40. Yes. 2 units of energy.
And
2 units of energy.
we already marked was given.
Huh?
Already marked is given.
You have got the marks for this. Then therefore whatever. So this is not a bone of contention.
My contention is not kindly hearing me correctly. My contention is that us canvassing that after challenging to this repetition, they accept that they made this.
So they should not have accepted.
No, they ought to accept
Therefore, we are saying, see, we don't make unnecessary submission. You say 4 questions are wrong. If this they have accepted, what do you have to submit on this?
They ought to accept for other question also.
So forget about that. We are asking you, what do you have to say about this one?
But they already get them.
Then this is over.
Next question number
Unnecessarily wasting time. Come to the other one.
13. Page number 67.
No, before that is 66. Before 67, there is 66.
Yes. 66 is question number 9.
Yes.
During school
No,
hours,
this one also they have not granted marks.
but they granted marks to other candidates. Part marks.
First, please answer our query. This is also a question which they have not rectified. So which are the 2 questions they have rectified? 40 and only 1.
That is 4A.
And the other 3 they have not rectified. All right. So 9 is
Page number 9 is page number 66. Kindly take page number 66, page number 71, page number 91, and supplementary affidavit, page number 20.
and where is your answer to this question number 9?
Page number 71. Where I have to annex the expert opinion.
Yes, where is the answer to this 66?
Page number 71. Bottom portion. The expert opinion, page number 91.
What is the expert opinion?
Page number 91.
Please read.
During school hours,
Therefore, I asked you, please read.
Yes, প্রদত্ত মেধা শেষ করতে 70%.
Sir, be kind to me, please.
That's why I translate.
Yes.
Yeah, already finished 70% of the homework. Actually, I make motion. In actually, Uttaravansi 1 to meet 1. That means I mean by 1 to 100% they convert it, and that means 60.5%. So whole unit 1. So what is the meaning of the 5 by 8? They want to canvas it, and that to 62.5%.
So what is the expert opinion?
Expert opinion, Neha do more percentage works. That
Yes.
is the expert opinion.
Yes.
Meenakshi ought to do more works. That's the expert opinion. And
So what is your answer?
my answer is 62.5%, and Neha 73%, and Meenakshi 62.5%. That's it. Neha do more work. That's my answer.
The question was who must finish a greater.
But
We'll come to you. Don't worry. We'll come to you.
But
Very well. Now, next question.
I just want to the similar answer is given by the another person.
Yes.
He got 3 marks. Our child takes supplementary. Supplementary affidavit filed by you. The last location, my lord. Want
Yes.
to know from where I got it, that answer. And my lord,
Where is the answer?
page number 20.
Page number?
20.
Yes.
There, my lord, the Public Service Commission gave 3 marks.
Sir, what is the answer? You are arguing as if I am able to understand this.
Answer is Neha basically. Neha do more work. That's the answer.
Where is the answer? I can't read.
Page number 20.
Why you give like this when you know that at least one of us cannot understand this? Then why you give like this? You are obliged to give a translation for your own benefit. For your own benefit. How will I understand? Huh? My God, how I know it is the same answer unless I can understand? You know that I cannot understand. Now I am here for 2 years. Everybody must be understanding that I will not be able to appreciate. That's why I said you are obliged for your benefit to give a translation so that I can understand. Your case can be understood by the bench. If you don't give, you continue arguing. It's a wastage of time. I don't know. I don't know what you are saying. You cannot. That's not the way. That is not the way. Because each and every word in this question and answer matters. Each and every word. So therefore, whatever you are saying is only a submission. Unless you give me a translation and a copy is given to them and they say, yes, this is the correct translation, how I can come to a conclusion? All right, then you proceed like this. You take the chance. We'll do whatever we want. What is this, sir? What more the bench can tell you? You are trying to compare two answers. The answers, whether they are one and the same, please listen to us, whether they are one and the same, unless we read each and every word, can we say that they are one and the same answer? How I can read each and every word of this answer? It is, sir. That's why we are saying. Please be kind to us. Whichever answer you want, compare. If the answer verbatim translation, due copy served, they will have to agree that the answer is same. Otherwise, they may say that you are giving a wrong translation. We don't know. After translating, coming back to the board, another appoint an expert. No. What expert? Expert has done it. I am not doubting the expert's opinion. I want to see whether your submission is correct or not. Sir, with greatest of respect to the candidate, he has a very strong belief that his answer is exactly the same as the other person. That is his strong belief and assertion which you are canvassing before us. Let us see whether the answer is one and the same. At least one question already. For that, no expert is required. Yes, I only have to read whether the answer is one and the same or not. What is the question? Where is the question of any expert? What expert will do? An expert has already been done. You must have read judgment of Ranvijay Singh. Whether we are required to do this after Ranvijay Singh judgment. No. What does Ranvijay Singh says? What is the opening line of the judgment of Ranvijay Singh? You read the first line of Apex Court judgment in Ranvijay Singh. Sir, please read. Where is the judgment? Sir, Kanpur University is of which year? Just see the opening line of this judgment. Just see. The first sentence. Please read. What a mess. That is what the Apex Court has said in the opening line. What a mess. Expert's opinion being looked into by the court. That is the expression. So therefore, forget about expert. You come with a translation, we'll see. The learned advocate represent. then we can.
I'm sorry, Madam.
Is every observation is not hostile. Some observations are there. So, yes. Let's see.
And it seems entitled. Already other candidate. I'm grateful. I'm extremely grateful.
Yes.
Yes. Item number 7.
Petition. That is one.
My lord, item 7, my lord, I am for the respondent, I am led by and senior counsel Mr. Arenbach. He couldn't available today code, my lord. Kindly keep it on next, my lord. On it, medical urgency couldn't come, my lord.
When do you want? Not
Next
today.
Not today, my lord. Just not today, my lord.
Not today.
Wait.
ঠিক করে দিন তো কি করলো কে জানে।
Item number 8.
Come, my lord, today.
It was adjourned to 1711.
Yes, my lord. This matter, my learned senior Sushant Paul, for this matter, my lord, he is engaged in the court. This 8.
11. Okay. What is our next date? So it is wrongly listed. Matter appears to have been listed wrongly today.
Item number 9.
I am for the response of 4 and 5.
Last matter, it has been given as 17 November, my lord.
All of them. So same order.
It has been
Same order in all. Huh?
on the last occasion, Lord fixed on 17 November.
So all these matters, they will come on 17. Huh.
Item number 14.
সব নিয়ে নে। Same order. Come up on 17th. Huh?
Very well.
No, is it? You are in which matter?
Under the
10.
impression that it would be taken.
Let us see 10. 10 also it is to come up on 17th. From where do you know?
Very well. As your lordship.
When it is not listed today, how you can file?
Item 14. The clock is.
For the petition.
Order টা করি ট্রাইব্যুনাল অর্ডারটা করি ট্রাইব্যুনাল অর্ডারটা করি ট্রাইব্যুনাল অর্ডারটা হ্যাঁ কই
This is a compensation appointment matter, my lord. My lordship wanted the state to produce the records, my lord, pertaining to the recommendation of the inquiry committee.
সেকেন্ড কি কই সেকেন্ডটা কই মানে I've got the part records part records
But my client has preferred a RTA application during the pendency of the writ petition. He has obtained the
The record relating to the consideration by the three-member committee.
Yes.
Did you get it?
no no 3 members committee report I have not got but according to
You have two
information-
copies.
Uh,
You have given him.
but he's according to the 100-point roster, his position is 7th. এটা কি এটা এসেছে এটা কি ইভেন্ট কমিটি রিপোর্টটা কই কই এইটা অর্ডারটা হুম কই কাটা কই তোমার পেমেন্ট এ দিন কই অর্ডার হুম That's why paid the people.
Where is the rejection order?
Page 74 of the writ petition.
পেজ মার্ক করে না, পেজ মার্কটা কে করবে? পেজ মার্কটা কই? 74টা কই? পেজ 74টা কই?
What is the date on which you applied?
At 10th of February 2017.
Seventeen.
Because my mother applied first, that is in 2014.
When did she apply?
9th of April 2014.
14.
14.
So within 2 years.
Yes.
What was the time for applying?
This was 1 year, but expired in November 2013, applied in for April 2014. It was
So within a
time.
year. Then what happened to your mother's application?
It was kept pending. It was kept pending. Thereafter, in 2017, my mother became ill. So I had to apply because my mother was not.
Where is your application?
Kindly comes to page 60. But 62 is my application. 62.
No, from where do we gather?
10 February 2017.
From where can we gather that this application is necessitated due to illness of your mother?
That is the letter at page 60. My mother's letter. I have produced this translated copy.
You have given a translation.
Yes.
Which page?
In the supplementary affidavit, page 7.
Page?
Page 7 of my affidavit.
Yes.
Application was returned.
That was for the documents, at page 59.
Page?
59. Document transport.
So it was still being processed.
My lord.
হচ্ছে যেন কোথায় আছে ওগুলো? স্যার আমি তো না না এই যে ও যে দিল আর তোমার হলো না কেন? কি করে দিল? আপনি তোমাকে তো চাইছো কোন ডিপার্টমেন্ট? হ্যাঁ
BS2, what is your case?
The-
According to them, you are time barred application.
Yes. But
What was the time limit at that time?
time bar, well, they say that I was a minor at the date of death.
So that means time barred
Yes.
because you are required to apply within 6 months or 1 year or 2 years. If within that period you attain majority, then you can do it. If you don't attain majority within that period, it becomes time barred.
But it says that, yeah, I have to be major as on the date of death. So I was not a major. That is why.
Where does it say on the date of death?
And I have annexed the amendments at page 11, my lord, of the supplementary affidavit. It does not say the date of death, it says 6 months.
Therefore, we said
Yes, ma'am.
it is not, the point is you have a window of a particular period within which you can apply. If you attain majority after 5 months and 29 days, still you can apply.
Right.
It's not a question of attaining majority on the date of death.
Now, my lord, as on the date of consideration of my application, this law has undergone an amendment and this clause has been deleted. And lordship will find that at page 12 of my supplementary affidavit.
This is of 2016.
2016, yes. So prior to my amendment, at the time of my application was being considered, this all has already come. And my lord, otherwise the recommendation is there in my favor, and there is also an additional clause inserted which says under exceptional circumstances it can be considered even after a substantial period.
But the exceptional circumstances are enumerated therein. There are two exceptional circumstances. One is no other person competent, and the other
It says, my lord, death during action where and two where none in family is eligible, etc. Department can
so
consider.
which of these two conditions you fall in?
My lord, my mother, the widow, was eligible and she applied. When had her application been considered, my lord, then I would not have been required to apply. And one hand, my lord,
Don't say had it been considered, you say had it been allowed because
Right,
it
my
was
lord.
still
Right.
being
Yes,
considered.
yes,
How do you know it was rejected?
yes. So had they came to a
But
finding,
that is not whether the authorities have a discretion beyond what is provided in the rule.
well,
The
in-
policy says only under two circumstances, a belated request can be entertained. That is if the death has taken place in action and if there is no other person eligible. So if your mother was eligible, there is no scope for your case being considered.
well, there is no delay in my application because first of all this clause has been deleted that here I have to be within 6 months I have to be a major, and secondly, my lord, this is now a continuation because my mother applied with
No.
even within 6
This
months.
is not deleted. This is very much there. The time limit is very much there, but now 10AA has been inserted by that amendment, which says it can even be accepted if it is belated.
My lord.
That means that time limit is there. You read 10AA.
In exceptional circumstances such as death during action where none in family is eligible, department can consider request for compassion appointment even where the death or retirement on medical ground of a government servant took place up to 5 years.
5 years. So this has been extended up to 5 years, but only in these two circumstances.
May
May I read the remaining portion?
Yes.
While considering such belated requests, these
Belated.
yes,
That means there is a time. That doesn't, that implies that the time is still there. And there is no conscious deletion or
my lord,
doing away with the time limit earlier specified.
kindly considers the second entry in that page itself.
Yes.
Dependent members shall invariably attain the minimum age for recruitment within 6 months from the date of death or incapacitation of the concerned employee, but the revised provision is deleted.
Correct. Correct. So there is nothing wrong with that. That does not mean time limit is gone.
That means, my lord, attainment of majority within 6 months.
Because it must have been extended beyond 6 months. What is the time limit?
6 months.
Even after this?
Yeah.
So where is, then why this 6C?
But a death took place 3rd November 2013.
Correct. Mother applied on 9/4/14.
And mother died on 1st May 2020.
Mother died.
Died.
When?
1st May 2020.
1st May.
Yes.
And what is the date of rejection of his claim?
Rejection was
17th December 2021.
Your claim is rejected in 21.
My lord.
21. At that point of time, her case was only considered, not the mother's application.
Her, he is the son.
He's a son.
I'm the son.
You are saying her case has been considered.
Himadri Chaudhary.
Himadri is son.
Himadri is a son.
When his mother's case was rejected?
Yes.
Was it ever rejected or not rejected? In fact, it appears that she has withdrawn her claim. When did she withdraw her claim? 10 February 17.
Yes. Yes.
Where is that document?
But that is page 60 later, my lord. Along with that, the application
Page 60.
60. The translated copy which is there in the supplementary affidavit.
No, the translated copy which we have seen from the supplement.
He withdrew her application. February 2017.
So you have accepted her withdrawal.
But in the meantime, the son applied. We have considered the case of the son.
But not in the meantime, on the same day.
Where is, see, if you have accepted her withdrawal.
Yes.
It is by which communication?
You kindly see the on 17 December 2021.
No, that is the date of her death.
No, 17 December 2021 was a rejection by the government.
He said that is date of death 17/12/21.
Date of death is
Expired on
1/5/20.
Yes.
1/5
Sorry.
1st May 2020.
Yes.
अरे बाबा एफिडेविट कोথায় তো মুখে বলতে রেকর্ড করে
So petitioner's rejection is 17/12/21. So where is the acceptance of her withdrawal?
kindly see the page 60 in Bengali documents.
No, that is her application for withdrawing. When you have accepted the withdrawal. So where is the final your rejection? This 17/12/21 document?
Page 74.
Page
74.
74. since mother withdrew the application, case of the son was considered.
So this is of 21. The amendment has come before this. Your amendment has come in 2016.
The amendment in 2016,
Then,
but death took place on 3rd November 2013.
yes. So when the amendment came, his application was still pending. Because it has been disposed of in 21.
2021.
So it was pending. Since 2015, it was pending.
My
No, no.
application was in 2017. I made my
10th
application
February
was in
2017, page 63. Pro forma application, page 63. Left hand side, bottom, 10th February 2017.
No, but his mother had already applied for him in April 14.
Yes, mother has applied in 2014, April 2019.
Mother applied in April 14. He gave his particulars in 2017. Three-man committee considered. Three-man committee found him fit on all parameters. And then in 21, you have communicated a rejection after death of his mother in 2020. These are the facts.
Three-man committee recommended on
Three-man committee is of 2000.
18. 2018.
November 2018.
Yes, November 2018.
18.
And after that recommendation, you have taken another 3 years. So since it was pending, where is the question of the amendment not applying? Amendment has to apply.
An amendment, but this amendment with regard to the 2013 circular, which was effected, notified on 2016.
14 double B of that amendment. Please read 14 double B. What is 14 double B of the amendment?
After issue of the notification, after complies with the revised instruction.
It's pending. It is undisposed. It has been disposed in 21, much after issuance of. Where is the tribunal's order? Where is the tribunal's order?
That is going to be certified copy.
4/4/24.
4/20.
4th April 2024. Okay.
You have to consider our learned
Number 16 and 17.
Right.
Yeah.
And for
Lord,
the
item number 16, I appear on behalf of the petitioner. Lord, can it be taken up on Wednesday, my lord, as per your lordship's convenience due to my personal difficulties?
You are appearing, Mr.
I am led by Mr. Kamlesh Jha, my lord.
Mr. Mukherjee, you are appearing.
yes.
He wants
Item
Wednesday. He wants Wednesday.
Wednesday, my lord.
As paid by learned advocate for the petition.
Obliged, your lordship.
And number 18.
For the petition should be led by Mr. Prasanna Gopchach.
Lordship, in this matter, I am being led by Senior Advocate D.N. Ray. Lordship, due to some personal difficulty, he is not available today. Lordship, kindly take up the matter on next week.
On next week.
Next week, Lordship.
Next week. 8 people are posted then after the vacation in January.
After
After the Christmas
next year.
January, because time is very short.
Huh?
The next week, Lord, I will be in a very inflexible situation. I may have to go to Supreme Court and other matters. Or may I just give a lordship with the kind of that? So let it be on the first week of December. Section 3. Let it on 17 November tentatively with that.
17. An accommodation is paid for due to unavailability.
Lordship, matter is posted on 17th December.
Yes.
Grateful, Lordship.
November.
November
Law-
11.
Grateful, Lordship.
And number 19.
Your Lordship, I am for the petitioner, Your Lordship. I am led by Mr. Sudipto Dasgupta. He is engaged in another courtroom, Your Lordship. Kindly make it not today, Your Lordship.
Not today. File it on Monday.
Number 20.
Same to you. Thank you. See, because it is the first day, if nobody is appearing, we are just not. Not today, yes.
9:31.
Your Lordship, I am for the petitioner. I am led by Mr. Sudipto Dashgupta, Your Lordship. Both are identical matter.
Not today.
22. 23.
Shubho Deepavali and
Thank you.
Lordship, both of Lordship.
Same to you.
And I'm filing my
Who is representing the
reply
other,
to and
other respondents?
Union of India is the answering respondent. I file my reply. One affidavit in opposition has been used by respondent number 3.
Union of India has not filed opposition.
Yes, no.
They have filed.
Yes, I am filing reply against the opposition filed by respondent number 3.
No, 2 to 4. You are representing 2 to 4 or only 3? So what about 2 and 4?
The notice was served, but they are not they appeared, but they did not choose to file affidavit in opposition.
On their behalf.
Orderটা কোথায়? তা আছে না? Orderটা দাও।
No, here and in the order it says Mr. Palit for 2 to 4.
I am for 3.
But madam, in the order of 30th July 24, Mr. Palit, MS Palit is appearing for respondent 2 to 4.
That is respondent.
But the order records she is appearing for respondent 2 to 4. On 30th July 24, on 29/7/25, in both these dates.
দেখছি।
Director of order.
Director of?
If your Lordship takes the order dated 30th July.
Yes.
Respondent number 1 also for Union of India appeared Rajendra Banerjee with Chipra Chando.
Yes, but
And
2 to 4 it is the same
yes.
council.
They appeared. That means
No, it says Mrs. Tapasi Sinha Palit for respondent.
number, it should have been respondent number 3 instead of 2 to 4. But 1 is 1, 2 and 2 in for Rajendranath Banerjee.
Now you read the third paragraph of that date.
Third paragraph. Yes. Mr. Banerjee advocate appearing as such a compilation.
Now after that,
Yes, respondents would be at liberty to file their opposition.
no, Mr. Banerjee appearing for the Union of India and MS Sinha Palit learned
Yes, that
advocate
is I am saying.
2, 3 and 4.
2 and 4. 2, 3 and 4. And prays to leave their opposition. Everything is in
That means we don't know whether 2 and 4 have been served or not.
May I come back?
Please find out ascertain what is the correct situation.
And if not, I am serving again, coming back.
Affidavit of reply filed on behalf of Is there any wakalatnama you have filed? Let us
1 minute, let me check.
just see. Because 2 orders record 2 to 4. How it can be wrong?
Yes, in the order sheet is recorded,
Yes.
not in the top.
No.
I believe they appeared.
That's not. Still for me. Certain anything from the front.
এইটা পেছনে তো তোমাদের ব্যাকশিট হবে না হ্যাঁ তো ওটা দেখিয়ে দিলে তো হলো
How you can not represent 3 and 2, 3 and 4? They are all the same respondent.
I checked it.
I filed and we have responded as by instructions.
Very unfortunate. Sir. What adjourn it? You are representing the audit department and you are saying I am appearing only for one respondent. How can you say that?
I responded. That's why I filed this affidavit in audit. But 2 and 4 my lord.
IPRA.
They are only representing set of India for my knowledge.
Amuda?
In the list of forward.
দাঁড়া দাঁড়া দাঁড়া। তুমি কাজটা হয়ে করেছো হ্যাঁ হ্যাঁ তো কি করেছো সেই জন্য রেকর্ডিং ওটা হয়েছে
Respondent. Yes, you are.
Not one. But I find this.
ঠিক আছে একই হবে একই হবে তুমি একদিন টাইম নাও সেটা ঠিক আছে
Three respondents will not file separate opposition. That means
yes they are responsive responding authorities responded it can be taken let it be another day করে দাও হ্যাঁ ব্যাস
I am the answer. My God, find only short.
then I need not serve again I may be relieved to that October fix করবে ওই একই
তারপর আমি যে
নাম দিয়ে দিচ্ছি
হ্যাঁ
124, 25,
my instructing advocate say 2 weeks advocate. Which one? 26. Instead of 1 week, let it be 2 weeks. He said.
all right, 2 weeks.
Yes, he's out of.
তাহলে ডেট কি 10 তো 7 11
7. Get
item number 24 I'm praying for not today.
Not today.
24 and 25.
24. Before it is called.
1925,
All right, not today.
1926, 27,
27, my lord, I am telling it to virtually, my lord, I am telling. My namaskar to you all.
You are for the petitioner. Yes.
No, I am for the Union of India. The land reserve matter, my lord, all the matter has been fixed on. That is on 10th November. Your lordship.
No.
Petitioner is not here, not today. Let him be here. Not today.
28,
29, 30, 31, 32, 33, 34, 35, 36, 37, 38.
I am appealing for the petitioner, or I am praying for not today.
39,
39, my lord. On behalf of Mr. Samant, my lord, Rohit Samant. He told me to pray for, let it be taken up after 5, 5th November. No. Mr. Surajit Samanta is for the petition. He told me to brought to your, yes.
Item 40, 41, 42, 43, 44, 45.
That's what I am praying for not today, man.
46.
Board is not functioning. Outside the court, my lord, board is not functioning. There is a problem.
Many
Very
courtrooms, many.
The main board
one
is
is functioning. My lord.
47.
47 not today, my lord. This is the bug for the other side, my lord. Everything, affidavits are all complete.
48.
Lordship, I appear for the petition. Lordship, there is one basic problem in this matter, Lordship. The respondent has filed his opposition, but in the opposition, it transpires that the respondent number 2 has already passed away before the opposition was filed, and it is being affirmed in his name, Lordship. So that is a technical fallacy which has to be addressed first, Lordship, before going into the matter. Lordship, my juniors are not here because of the board.
Not today. Call the next case.
49. 50. 51.
Your Lordship, 50, 51 and 52, could it be taken up after Wednesday?
50, 51, 52. 53 to 55.
Next go. Next one.
Item 56.
Lordship, in item number 56, I appear for the respondents, my lord.
Not, since nobody is appearing.
Item
Lordship,
57.
grateful.
Item 57. 56 not today হয়ে গেল তো 56 not today সোমবার item 58 59 60 61 62 63 64 65 66 67 68 69 70 71 72 73 74 75 76 77 78
Mr. Anil Kumar Gupta appearing for the petitioner is currently out of station. I'm paying him not today.
79 80 81 82 83 84 85 86 87 88 89 90 91 92 93 94 and 95
Lord, I am for the respondent.
Petitioner therefore not today.
96 97 98 99 100 and 101 102 103 104 105 106 107 108 109 110 111 112 113 114 115 116 117 and 18 119 120 121 122 123 and 124 125 126 127 128 129 130 131 132 133 134 135 136 137 138 and 139 140 141 142 143 144 145 146 147 148 149 150 151 152 153 154 155 156 157 158 159 160 161 162 163 164 165 166 167 168 169 170 171 172 173 174 175 176 177 178 179 180 181 182 183 184 185 186 187 188 189 and 190 191 192, 193, 194, 195, 196, 197. 102 both sides are there, Maharaj. 198, 199, 200, 201, 202, 203. That is
Complete. Paul? Yes.
204, 205, 206, 207, 208, 209,
I am for the respondent, 109.
Yes.
210, 211, 212, 13, 214, 215 and 16, 217, 218, 219, 220, 221, 222, 223, 224, 225, 226, 227, 228 and 229, 230 and 231, 232, 233, 234, 235, 236, 237, 238, 239, 240 and 241, 242, 243, 244.
Yes. You are not a new council. You are not new. You should know better than to wait for the list to be called rather than saying in between.
Sorry, Maharaj.
Yes, which matter you?
102, my lord.
Who is for the other side?
My learned friend.
You are for the petitioner. 102. Mr. Mukherjee is appearing for the respondent. Mr. Mukherjee is appearing for this.
Next to Puri, WPS 56 of 56.
After lunch, 102. That is the only matter
number 102.
कोई original application টা কই? হুম?
This is the petition, my lord.
কি ওটা? সেটা দাও তো, দাও।
Hmm.
এই কাজটা একটি গন্ডগোল হয়েছিল বারবার করে আগে
In the verification role, which column is meant for disclosing pendency of a criminal case?
Page 30 of the document file, paragraph 30. Page 30 just now, the document page to be allotted.
No, we are asking you which column requires disclosure regarding the criminal case.
Yes, column number 30. 30. Have you ever been arrested, detained, or convicted by court of any offense with the particulars of the arrest, or detention or conviction and sentence should be given? NA, not applicable.
This is regarding arrest or detention or conviction. We are asking you regarding pendency of criminal case. Are you accused of any?
He was arrested.
We are asking you whether the verification role requires disclosure of pendency of a criminal case.
Well, can you see the language? Have you ever been arrested, detained, or convicted by court or any offense? If answer is yes, the full particulars of the arrest or detention or conviction and sentence should be given. Not applicable.
Correct. So now
That means
again we are asking you.
Detained. He was arrested.
Where is the dispute on this?
There is no dispute.
So we are not bothered whether he was arrested, not arrested, whether he has disclosed about his arrest or not. We are asking you, was it required to disclose pendency of any criminal case?
Disclosure that's whether he has been arrested or not.
No disclosure regarding pendency of criminal case.
No. Whether you have been arrested. First sentence. But he was arrested, admitted position.
Again, you are repeating the same thing. We are asking you whether any column requires disclosure regarding being made accused or any criminal case.
Only paragraph 13.
Apart from that, there is nothing. So when he was arrested?
Arrested, just give me 1 second. 2000. Arrested on 8 September 2002. And this verification column was filled up on 16 November
2,
2009.
and he was released on bail on
9th September 2002. Immediate. Just.
So even if he is arrested for 1 hour, it means he was arrested. It does not mean he was not arrested. Where is the order passed in the first way? 751 of 2011.
If you are not arrested, they don't ask you.
64 my lord. 65. Page number 65.
You are arrested. Once you are arrested, also that
Yes.
Page 65 my lord.
এটা কি 57 হতে হবে?
Now he is Did you file opposition in that OA? 5.1.
755.
In the earlier OA,
No. I don't.
511 of 2011, was any opposition filed by you?
At the admission stage, it was disposed of. Kindly see the order number 2, page 65. Relying upon the judgment of the Supreme Court, State of West Bengal versus Nazrul Islam. You do not require any formal reply from the state government, and the matter can dispose of the wishes made by the petitioner.
But this order is binding inter parties.
What about the direction given by the Supreme Court? What about the direction given by the London Tribunal that if he is acquitted in a criminal case, then he can approach? That is the direction of the tribunal. That is page 67. State of West Bengal versus Nozul Islam reported in 2011-10 SSC 24 from the report decision to find that the similar question was raised before their lordship Supreme Court of India whether a probationary sedated can be given appointment if criminal case is pending against him, and their lordships answered that such can no order be given the state government and for issue of appointment letter so long the criminal case is pending and the incumbent has not been acquitted of the criminal case. Following the said decision, Supreme Court of India will dispose of the application that the petitioner claim for appointment would arrive if he is acquitted from the criminal case. After that, Manad, we got a report from the Home Department.
He is seeking appointment on LDC post.
LDC post.
In which department?
No, yes. Food and supply. Food and supply. And I have placed before your lordship Suresh Jadhav and Avtar Singh.
We don't remember.
I have supplied it. Judgment 536.
Satish Chandra Yadav.
Satish Chandra Yadav.
This is after Avtar Singh.
Avtar Singh has been considered. Avtar Singh is at I think it is 2016 8 SSC page 471. And Avtar Singh has been considered by Justice Padriwala and certain guidelines have been issued.
Where is that?
Huh?
Where is that, Judge?
Avtar Singh 2016 8 SSC and
No, we have Avtar Singh. You need not give again.
2023 7 SSG 536 paragraph 93 that is 20 Satish Chandra Yadav paragraph 93
Paragraph 19.
2023 volume 7 SSG 536 Satish Chandra Yadav versus Union of India. I think it has been considered about 47 judgments. Even in case where the employee had made a declaration truthfully and correctly on a concluded criminal case, the employer still have the right to consider the antecedents and cannot be compelled to appoint the candidate. The acquittal in criminal case would not automatically entitle a candidate for appointment to the post. It would be still open to the employer to consider the antecedents and examine whether the candidature concerned is suitable fit for her. The suppression of material information and making a false declaration in the verification form relating to the arrest, prosecution, conviction, etc., has a clear bearing on the character, conduct, and antecedents of the employee. If it is found that the employee was suppressed or give false information in regard to the matters having a bearing on the fitness or suitability of the post, he can be terminated from service. On the last action, I have already handed over. Yes.
Last moment, ideas.
আমি কিছু জানতে পারতে এখন তো
24 মানে যারা চেম্বারে 24 হ্যাঁ 24 লেখা নেই ডিসপুট সার্ভার হয়ে গেছে সার্ভার হয়ে গেছে অনেকগুলো ফাইল একসাথে that has already considered all the judgments on last occasion my lord seen the kindly see the my lord's order my lord on 26th August 2025. So far as my lord Satish Chandra Yadav, the judgment of Pawan Kumar also considered by the Honorable Apex Court. My lord, that thing also considered in the Pawan Kumar my lord. Where my lord, the case is in tribal in nature, my lord. The same can be considered, my lord, suppression of facts is not my lord. The my lord, fatal for giving any appointment.
Suppression is not fatal.
So kindly
Please read that part from the judgment.
exact. I used to the order of the Pawan Kumar's my lord.
Yes, tell us which paragraph.
Tribal in nature, my lord. My lord, the criminal case indeed was a tribal in nature and the nature of post, in nature of duties of to be discharged by the circuit by the truth has never been looked into the Occasion Authority while examining the overall stability of the conflict income and keeping view of the rules such and such. Taking into consideration of the exposition expressed by this court in Avtar Singh Supra. In our considered view, the order discharge passed by the competent authority on Saida is not substantial and in sequel thereto, and the judgment passed in the division bench of the Delhi High Court and does not hold a good and deserve to be set aside. Furthermore, my lord has considered that my lord the earlier official the learned tribunal has already concluded that the petitioner acquitted from the criminal case will be cases which are to be considered by the authorities. And that order is not challenged by the authorities.
Suresh Yadav has not been considered.
Suresh Yadav, my lord.
Pawan Kumar reported in 2023, 12 basis, page 317. Suresh Yadav has not been considered.
My lord, Suresh Yadav.
No, what is the date? What is the date of Pawan Kumar judgment?
Pawan Kumar advent in 2nd May 2022.
Like, in case of Suresh Yadav, for judgment of the
So Satish Chand Yadav is later judgment.
in, uh, in case of Suresh
And Pawan Kumar has been considered. In
case 60,
Pawan Kumar has considered only the observing.
Huh?
No, Pawan Kumar has considered observing.
No.
in Satish Chandra Yadav,
In Satish Chand Yadav, even Pawan Kumar has been considered. Therefore, we are asking you.
Paragraph 63, my lord. Satish Chandra Yadav, my lord, Pawan Kumar has been considered by the school, Honorable Apex School, my lord.
And after considering what the Apex Court has said,
Case of the my lord, Satish Chandra Yadav is different, my lord, in case of present case of the petitioner and also my lord, Pawan Kumar.
how? What is the distinguishing feature?
Was not tribal in nature, my lord, possible, my lord.
No.
Tribal in nature, my lord.
All right, we accept that it was not trivial in nature. Then, so what is to be done? That is what we are asking you.
My lord, my district submission is my lord.
Therefore, we asked you, you said that the court has said that if it is trivial in nature, it will not be fatal.
That is my
That you are not able to show.
lord.
Plus, after considering Pawan Kumar, what the Apex Court has said in paragraph 69B, you read it. Oh, sorry, 69C.
Suppression of material fact, information, false statement.
C. The suppression of material information and making a false statement in the verification form relating to arrest, prosecution, conviction has a clear bearing on the character, conduct and antecedent of the employee. If it is found that the employee had suppressed or given false information in this regard, meaning arrest, he can be terminated from service.
My respect to submission was my lord, mistake on the part of the petitioner, my lord. And I, in the reply, I have my lord, submitted before the my lord, tribunal. There is a mistake, my lord. Since my lord,
Show us from the pleading in OA 511 where you have said that due to mistake we have not mentioned. Go through the OA 511.
911.
511. 911.
My lord, in reply, I have submitted, my lord. Rejoinder, my lord.
Rejoinder.
In your OA 751 of 2011, in 751 of 2011, have you said that because of mistake, I have not mentioned this?
But in which this question was not arose at the time of 751, they have not. I have also annexed,
So you, because they did not raise this, you did not mention?
I have annexed the verification goal, my lord. Can you see the
Yes, it is an extra F. I have seen, therefore we are asking you. You have enclosed an extra F. You have enclosed the police verification form. So have you said that due to mistake I have made a wrong mention?
that mistake was not, my lord, detected by me also, my lord. That is why, my lord, that was not disclosed, my lord. But my lord, criminal case was disclosed, my lord. Can you see the, my lord?
What is the mistake?
It's true, my lord. My lord's contention is correct, my lord. But my lord,
Nothing, you have nothing.
my lord,
Nothing can be done for you.
my lord, one thing is, my lord, the order passed by the earlier occasion in 7.
You had all the opportunity in 751. You did not do it. You had all the opportunity in the second OA. Again, you have not said. In rejoinder reply, when everything is over, then you say mistake.
Yeah, in their, my lord, in their order, my lord, can you see their order issued by the authorities, my lord, regarding unsuitability, my lord. My lord, they have not. This point was not. They have also taken in their order, my lord, issued by the regarding the unsuitability, my lord.
Okay.
This point was raised in their reply only, my lord. in their reply, they have taken this point, my lord. In the order issued regarding rejection my appointment, my lord, they have not taken this issue, my lord.
It's a reflection on his character. Honestly, that's every part time as a bear. Every part time. If it is found that this then regarding to the matter that he can take me a Khichuri festival. Nolengurer bias. सब कॉलेज not today very. আবার হবে খেতে গেলে গন্ধ লাগে আমার তো এখন মাটন খেতে গেলে আমি দেখেছি মাটন মাটন যেটা Date of tribunal's impugned order. Yes. Disposed. 13/12/24.
December 2024. On suppression of material facts, it has been decided.
Submission is earlier order passed by the tribunal, there is no appeal disposed. That they have not, but in the order of rejection, they have not taken into consideration the suppression of facts, etc., my lord. After filing the secondary OA, my lord, they have come with an application and rejoined the reply wherein they have disclosed that that I have suppressed the facts, my lord. And my lord, it is actually, my lord, a bona fide mistake. Since it is mistake, my lord, that mistake was not detected at the time of the filing application in the year 2011 also, my lord, by the petitioner. That is why, my lord, the way my lord kindly considered, my lord, if it was within the knowledge of the petitioner that he has suppressed some material facts, my lord, copy of the my lord verification roll to not be annexed in the said petition. But he has annexed in the petition. It was not within his knowledge also, my lord, that he has a mistake was done by the petitioner. It is actually very mistake on the part of the petitioner. My respect to submission is, my lord, there is no intention of the petitioner regarding, my lord, suppression of material facts, my lord.
He has already annexed in the original way of 2005 in 2011.
Yes, my lord. That is why, my lord, he has annexed.
He has got the knowledge. It was
mistake
signed on 16 November 2009. He has no knowledge.
Had it been, my lord, his intention to suppress anything, my lord, the same could not be, my lord, annexed in the said petition, my lord. It is my respect to submission. It was not also detected by him, my lord, at the time of 2011. The responding officers are also not detected. And at the time of the order of the rejection, they have not, my lord, issued any term regarding suppression of facts, my lord. Can you see their order of rejection? Nothing, my lord. Can you see? And now, my lord, whether, my lord, they can raise this issue at that by filing a reply, which is not in their order of rejection, my lord. My lord, kindly come to my page 73, statement of facts, and then 74, my lord, order of rejection issued by the authorities regarding unsuitability of the petitioner. On 25th March 2010, IB West Bengal received memo number such and such from SP such and DIB Nodia regarding VR inquiry of Naran Patanda such and such. It was learned from the VR subject was a FIR named accused of Dhankala PS case number such and such. He was arrested on 18 September 2022 and on 19 September 2002 he was released on bail. The case was pending for trial in the court. Thereafter, IB West Bengal returned the verification role to the appointing authority, Food Corporation of India Supplies, West Bengal, such and such, with no opinion.
Where are you reading, sir?
Well, at page 73 of my original application. Page 73. The order issued by the authorities regarding rejection of the
It's a statement of facts.
This is not a rejection order.
Thereafter, the order.
That is also not a rejection order.
Verification of CS.
That is not a rejection order. That is an interdepartmental communication.
Well, thereafter, 75 mile also. Joint director verification.
That is also not a rejection order. Where is a rejection order?
Clearance, no rejection order was issued, my lord. And my lord, it is a clearance regarding verification, my lord, role. Consideration of the verification role. They have considered the verification role, not taken into consideration that I have suppressed the facts. Observation regarding the verification. I just formulated a mere mistake, my lord, on the part of the petitioner.
Yeah, these questions.
Yes, let's just see what it says.
Even 28 disposed. 28 disposed. Overnight.
একশো বারো থেকে 15।
Any judgment after this? September 22, after September 22, any judgment is there?
I have not searched whether they are less than 10, my lord. I have to allow some time to search whether any further order was there, my lord. In this respect, my lord. So, common core also, my lord, consider that if the case is in tribal in nature, my lord, that is required for consideration, my lord. And my lord, so this of the-
Repeating the same submission so many times, does it help you? The submission remains the same, whether you say it once or you say it 10 times. The submission remains the same. Again, you will say, again, we'll ask you where it is, then you will not show it. What is the point? 69C is very clear. Therefore, we are asking you whether this aspect has been considered after this or not. If not, then there can hardly be any scope, prima facie.
So far, the order of the tribunal in OA number 751, they have not, my lord, appealed against.
That is also a repetition. That also you have already submitted. What should we do? Just see if there is any judgment after this. Or the advocate.